You laid down why you and the Heritage Foundation was pushing this choice of Brett Kavanaugh. You talked about his pedigree and his service. Where were all of those standards when President Barack Obama nominated Merrick Garland, who was actively stalled and actively blocked for over a year? I mean, he certainly had pedigree. He certainly had a long record. So doesn't it seem hypocritical to now have a different standard for this nominee than you used to stall the nomination of Merrick Garland? I mean, let's talk straight here. What happened to pedigree and record then?
Fair enough. Let me, and I will respond to your question. I just want to respond to a couple of things that Christian said.
No, first respond to my question.
Fine. I'll respond to you. You are not going to hear me say anything negative about Chief Judge Merrick Garland. Chief Judge Merrick Garland is a fine public servant.
So then he should have been seated?
If I could just finish.
Should he have been seated? Yes, you can finish, but should he have been seated?
That was a decision made by the Republican Senate that in a presidential election year where a justice is going to be sitting for as long as 25 or 30 years, and with the Supreme Court very much on the ballot for the first time in a long, long time, that was a decision that should be made by the people. It was quite a gamble because everyone expected Hillary Clinton to win and appoint somebody who was younger and more progressive.
Why can't the people make a decision now? We're going into a midterm election with a president under investigation. Well, what happened to the will and the right of the people now?
Okay. First of all, it's not a presidential election
So
year.
what? It's still going to decide where we're going the next 20 or 30 years. It doesn't matter which office. This is a decisive election, and the president is under an active investigation where there's already been convictions and guilty pleas.
Reverend, with all due respect, so was President Clinton when he nominated and got confirmed both Ruth Bader Ginsburg and Stephen Breyer. It is the man in the office who does the nominating that makes the difference in who is on the Supreme Court.
Well, then why wasn't it the man in the office, Christian, when Obama nominated Garland? I think his point is my point. Clinton was able to get things through. Every president was. Why was it a different standard for Barack Obama?
It's a double standard, and the folks who have been controlling this process, Chairman Grassley and others, speak from both sides of their mouth. During Justice Kagan's nomination, folks like Jeff Sessions insisted on disclosure of each and every document from Kagan's time in the White House. But now we see the Senate at every turn changing the rules of the game, abandoning the long-standing traditions and rules that have helped guide the most important task that the Senate carries out, installing lifetime judges on our nation's courts. This hearing should not be going forward on Tuesday. We need a press pause. We need to give the Senate time to evaluate each and every document underlying Mr. Kavanaugh's record so we can understand who he truly is before we think about whether he qualifies for a lifetime seat on our nation's highest court.
All right, let me go back to John, because I promised you could respond to what Christian had said before, and I had interrupted with my concerns. So to show I am fair and balanced, let you respond.
I appreciate that, Reverend. First of all, over twice as many documents have been produced for Brett Kavanaugh as the next lowest number for any other nominee in the history of the Supreme Court. So what if they're
not all the documents? What difference does that make?
Reverend, very simply. So Christian just talked about Elena Kagan. From her time in the White House counsel's office, all of those documents were produced. From the time that she was the Solicitor General, none of those documents were produced because they involve executive privilege. From Brett Kavanaugh's time in the White House, every document from when he was in the White House counsel's office has been produced. Where executive privilege has been asserted is for documents that passed over his desk that involved decision-making directly by the president. That is a traditional usage of executive privilege. And the other thing that I would just say in response to something that you said is that Brett Kavanaugh has suggested that Congress may want to pass a law that would prevent a sitting president from being sued. There already is a Department of Justice memorandum that says a sitting president cannot be indicted. There is no reason to believe that as a judge that he could not sit in judgment of the president, just as four Nixon appointees ruled against. Hang on one second. Just as four Nixon appointees.
The Justice Department is not a law. There is no law saying that a president cannot be prosecuted. There is a memo in the Justice Department.
That is correct.
Which means absolutely nothing. It will go to the Supreme Court, and if this judge is already predisposed to prejudge that shouldn't happen, the American people have a right to know that.
Reverend, with all due respect, that's not correct.
What is not correct?
There is an opinion within the Justice Department, which means that the Justice Department cannot charge him. So it's not going to get to the Supreme Court.
No, but there's no law preventing them because they can turn around and change the same memo. Is that not correct? Well, that's what I said.
If they change that memo, then he could be indicted, possibly, and a case could make its way to the Supreme Court. But Brett Kavanaugh has not said...
we need to know where Kavanaugh is, since Kavanaugh has writings that has not been made available. We do not know if he's taken that position. That is why we need all the records.
Brett Kavanaugh has said nothing about whether or not, as a matter of...
We do not know that if we can't get the records. We want to know what he said. And just like you stalled Garland, why can't we wait and see what he said? Not what he says he said, but what he said.
Reverend, if I may finish, he has not said that as a constitutional matter, a sitting president cannot be indicted. He has never hinted
at that. Let us see the record then.
In terms of the documents that have not...
Let us see the records of what he said. I've got to go. We can go all day with this. Let's see the record of what he said. Thank you very much, Christian Clark and John Malcolm.